Hey all, it is Sunday, the 6th of March. And what I have for you in today's Sunday edition is basically the very brief history of CRISPR, all the people who actually participated in discovering components of CRISPR to get it to where it is today. And along the way, we also have instances where each parties had filed for IP. So the story that I have for you today consists of two stories intertwined with each other. The first storyline is basically all the people who identified and discovered CRISPR. And the intertwining storyline that goes in parallel is the IP applications from Broad Institute as well as from the CVC. And this particular video is going to take you right up to the latest decision that we had, granting the IP rights to Broad Institute. And it also talks about what happens next. And I also give you my own thoughts of what needs to happen next in order for this particular tool to be used for the benefit of humanity in general. So let's get started. So our story starts with Francisco Maica from the University of Alicante, Spain. And the story is somewhere in the 1993 to 2005 time range. And all the things that I'm presenting here is based on my own research from three sources. One is the Wikipedia, which fills up all the blanks. I have got one of the sources from Broad Institute, and the other source is a reference from berkeley.edu. I'll put the links in the description below so that you can look at them yourself and look at the source of the information and do your own research. So Francisco Maica was the first researcher to characterize what is now called CRISPR locus, reported in 1993. Francisco also was the first one to coin the term CRISPR. And he was the first person in 2005 to hypothesize that CRISPR is an adaptive immune system. So I didn't know about this. I don't know how many of you already knew about it, but this was absolutely new for me when I did this research. So the story of CRISPR doesn't start with Jennifer Doudna and Emmanuel Charpentier and Zhang, but it's been in progress since 1993. So that was a revelation for me. The next contributor in this story is Alexander Bolotin. In May 2005, when he was working with French National Institute for Agricultural Research, he was studying the Streptococcus bacteria, which had just been sequenced. And he identified unusual CRISPR locus, and his research led to the discovery of Cas9 and the protospacer adjacent motif, which is now the famous acronym PAM, P-A-M, that is required for target recognition. So basically in 2005, we had the discovery of Cas9 and PAM. Our story next moves on to Philip Horvath in March 2007, somewhere in France, with a company called Danesco France. Along with his colleagues, they studied the Streptococcus bacteria, which is used in the dairy industry to make yogurt and cheese. And Danesco basically produces rennet for lactic fermentation. This is the background in which Philip Horvath and his fellow scientists were working. And it was his work which was integral to the development of CRISPR Cas9 as a versatile biochemical method for targeted genetic engineering. And for this work, he was awarded the 2015 Massey Prize along with Emmanuel Charpentier and Jennifer Doudna. In March 2006, Eugene Koonin from US National Center of Biotechnology Information hypothesized that the Cas group of proteins is more of an immune system rather than a DNA repair system. So that was his contribution to this story of the evolution of CRISPR-Cas9. In August 2008, John van der Oost from the University of Wageningen, Netherlands, demonstrated that the spacer sequences are transcribed into guide RNAs. And this was done through a study of E. coli spacer sequences. Even at this point of time, nobody had filed any patent for CRISPR or Cas9 or anything. We are still in the early days. And December 2008 sees two scientists get together, Luciano Marafini and Eric Sondheimer from Northwestern University, Illinois. And they demonstrated that target molecule for Cas9 is DNA and not RNA. This was further refinement of interference to demonstrate that CRISPR acts on DNA targets and not RNA. So we can see that the story is slightly getting more and more refined, and we are moving towards a situation where someone is going to come and say, okay, this is CRISPR and this is Cas9. You put them together with, and you can use them as a tool for editing DNA. So as we have seen earlier, that by this time CRISPR had been identified, PAM had been identified, Cas9 had been identified, and subsequently in 2010, the duo of Luciano and Eric, they managed to demonstrate that CRISPR-Cas9 creates double-stranded breaks in target DNA at precise positions, 3 nucleotides upstream of the PAM, and that Cas9 is the only protein required for cleavage in the CRISPR-Cas9 system. So this is as definitive as it gets to our understanding of CRISPR-Cas9 as lay people. And let us see how the story proceeds, because we are coming very close to the point where someone is going to apply for the IP. So now we got subsequently just a few months from there, I think in March 2011, Emmanuel Charpentier happened to get together with Jennifer Doudna, and they kind of began their collaboration. From this point on, the story is well known. Many people have told this story. So they were the ones who put the puzzle together. And this was a very important discovery of tracer RNA for Cas9 system. And subsequently, they went ahead and filed the first patent on behalf of UC Berkeley and the University of Vienna, and we are going to call them as CVC. That's the name that's being used in most of the media articles to describe this consortium of universities, which were represented by Jennifer Doudna and Emmanuel Charpentier. So they filed the first patent application for CRISPR-Cas9 gene editing in all environments, including bacteria, plant, animal, and human cells. And as I told you in my earlier video, the way the US patent system works is that it's like a black box. There's an entry, people go and file their patent. Nobody knows what the other person has filed. So many times the same idea could be patented in parallel by multiple people. Whoever comes in first and whoever has clearly demonstrated the concept is the one who generally wins. But this whole process of going through the patent and searching worldwide to see that nobody has filed something similar and nobody else holds that patent, all those things, I think, archaic details. I mean, you could research it separately, the way the patent office works. But the whole process takes around 16 to 18 months. And after that period of time, the patent office will award patents or ask for more information or settle disputes, if any. So at this point of time, what we know is that the first party to file for CRISPR-Cas9 IP for all environments was the CVC group. The next contributor to our story is Stiksniks from Vilnius University, Lithuania. What he did was he cloned the CRISPR locus from a Streptococcus bacteria, which is a type 2, and introduced that into E. coli, which is not a type 2, and demonstrated that CRISPR-Cas can move across species and still perform its function, and therefore it is a self-contained unit. And this was a very important discovery because it shows how versatile the CRISPR-Cas9 tool can be. You can see that very quickly by June 2012, Charpentier and Doudna, and almost at the same time, Stiksniks had demonstrated that they could reprogram Cas9 to target a site of their choosing by changing the sequence of the CRRNA. This was again further refinement where we first knew that there is CRISPR, then we knew there is Cas9, then we knew that there is PAM, And we knew that the editing can take place 3 nucleotides from PAM. And now what they have done is they have been able to demonstrate that they could actually do edit at the location of their choice using CRISPR Cas9 by changing the sequence of the cRNA. And one more thing happened around the same time in the Q4 of 2012, around the time that Sixnix demonstrated this. Toolgen and Sigma, two companies, also filed for intellectual property for CRISPR's use in eukaryotes. So there is no decision yet from the US Patent Office about Toolgen and Sigma's application. And during their communication very recently, while granting the IP to Broad Institute, they sidestepped making any mention about Toolgen and Sigma. So we still have to see what's going to happen to the patent application from Toolgen and Sigma. In June 28, 2012, Doudna and Charpentier team published the first scientific article detailing their gene editing discovery, describing everything so far. And from an IP perspective, this kind of gives a bit of a significance in the sense that not only were they first to apply for the IP, but also they were the first to publish the paper. Not much later, in December 12, 2012, the Broad Institute, which is the other side of the IP battle, this is a collaboration between Harvard University and MIT. They filed the patent for the use of CRISPR-Cas9 in plants, animals, and human cells. The significance from an IP perspective is that they were the second to file for patent in the US Patent Office. So that is the story of the two, actually 3 IP application. First from the CVC, second from Sigma and Toolgen, and third from Broad Institute. In the IP battle, there was a lot of back and forth between CVC and Broad Institute because Feng Zhang was the very first one to demonstrate CRISPR-Cas9 in genome editing. So all the earlier presentations were theoretical, and what Zhang had done was practical. So the IP rights were obviously given to Broad Institute because they were the first to demonstrate, whereas the CVC was arguing that the theory of presentation was the first from their side, and they had also done similar actual demonstration around the same time, and they argued that unless whatever was demonstrated was materially different from what they theorized, they should be getting the IP. So that's the argument from the CVC side. On April 15, 2014, the Broad Institute received the first patent for CRISPR-Cas9 specific to plant and animal cells. So as soon as that happened, CVC went and filed an appeal. And on February 15, 2017, the Patent Trial and Appellate Board, PTAB, found that Broad's patent claims do not interfere with UC's patent claim. And UC is basically CVC. And PTAB did not reach a decision as to who was first to invent the CRISPR in plant and animal cells. In May 2017, European Patent Office granted the CVC team the first CRISPR-Cas9 patent in European Union, which covers 35 countries. The patent covers use for CRISPR-Cas9 in plants, animals, and human cells. So now we have a situation where Broad Institute has the IP in US and CVC has the rights in EU. And there are other countries, many of them which follow US Patent Office. They will depend on the outcome from US Patent Office, and the countries that depend on EU Patent Office will follow the verdict from EU Patent Office. That's my understanding. And in March 1, 2022, that is very recently, and I actually published this in a recent video, I think last week, the US Patent and Trademark Office finally decided that Broad Institute has priority over University of California. And once and for all, they settled that the IP rights for CRISPR-Cas9 gene editing in eukaryotes belongs to Broad Institutes. So right now, the remedy for CVC is to make one more appeal to the federal court and take it from there, and they will go ahead with it. Several proceedings are still ongoing, including interference claim by biotech companies like Toolgen and Sigma that I mentioned before, which filed for intellectual property for CRISPR's use in eukaryotes back in the fourth quarter of 2012, just before Broad Institute did. And in terms of my conclusion, I think that all this battle for CRISPR-Cas9 is going to delay progress on CRISPR, because companies that do not have IP license at this point of time cannot take a risk of signing up with either parties, as CVC can still appeal at the federal court, and there is no ruling yet on Toolgen and Sigma claims. And the companies which have already signed up either with CVC or the Broad Institute, they are in a different situation. The ones signed up with the Broad Institute are happy because their IP is safe, and all the work they have done on the basis of that IP is, can be monetized. There is no claim on that. Whereas the companies that got their IP from the CVC, they are having problems. Their stock values have fallen, and they have this contingent risk which is starting to materialize pending CVC's appeal to the federal court. So right now the hope for them is that maybe the appeal in the federal court may work out. And on the other side of it, the companies that got IP right from Broad Institute have that as a contingent liability. If CVC were to succeed in their appeal at the federal court, then that would go against them. So this is a kind of a messy situation. And in this situation, companies which have not yet signed up for CRISPR IP or signed up for collaboration will think twice before getting into the fray right now, because they would not want to invest a lot of money and then later on find that the foundational IP itself was not valid. So that's why I think it's going to delay the progress of CRISPR-related therapies. On top of CRISPR-Cas9, there will be other IP filings and decisions pertaining to refinement and other proteins and other approaches for CRISPR-Cas9 use. For example, in the last month or so, I have bought a lot of news articles that talk about Cas13, Cas11, Cas3, so many other Cas, and the mini Cas, which has been used very effectively for edits. And also, I think a couple of days ago, I published a daily update in which I had a news article that spoke about how scientists have been able to refine the targeting so that off-base edits can be reduced significantly. So all those discoveries will need to be patented on top of the CRISPR-Cas9. So a lot of moving parts are in here, and legal clarity is probably not there to take huge decisions for investing millions and millions of dollars. So I think that given that Broad Institute has openly advocated many times that they are open to joint ownership of IP along with CVC in order to avoid costly legal battles, if CVC were to accept that, then there is a chance of a good compromise. And that compromise will become a win-win situation for all parties. However, still the suspense out there is what's going to happen to the application of Toolgen and Sigma. If they end up getting some rights and being commercial organizations, they may not be like the academic institutions in terms of being open to collaborating and jointly sharing the IP, because they have to report to their shareholders, and such a momentous advantage is not something a publicly traded company or a company owned by shareholder is going to give up easily. So we'll have to wait and watch what happens. So that's where we stand today. And this, I think, is the most definitive summary of this entire CRISPR story, along with the IP applications and where it stands as of today, that you can find anywhere on the net. And if any of you are already scientists and who are very familiar with this field, if you find anything wrong in this story, please put it in the comments below, and I'll try to address that. And I hope you all liked this video. Please put a like there. And also, if you're here for the first time, please subscribe to our channel and become a part of our community. This is a CRISPR stock investment community, and you'll find a lot of interesting articles on CRISPR, as well as technical analysis and fundamental analysis on CRISPR stocks. So you're most welcome. Thanks, and have a great day. And I hope you have a great weekend. Bye for now.